Former President Jacob Zuma's bid to privately prosecute journalist Karyn Maughan and prosecutor Billy Downer has been rejected with costs. The High Court in Pietermaritzburg handed down the judgment this morning, and the former president had accused Downer of leaking his medical records to Maughan. The pair turned to court to challenge this. Our reporter eNCA's Lethiwe Mdluli is following this story and joins me now for the very latest. Lethiwe, good morning to you, colleague. What can you tell us regarding, of course, this judgment in court?
Well, good morning, Dumelo. We are outside the Pietermaritzburg High Court. The judgment did not take long. It was a short judgment, and we do understand that the judge has ruled in favor of Maughan and Downer. But right now, I'm joined by Mpumelelo Zigalala, who's going to take us through some of the specifics from this case. Mpumelelo, thank you so much for joining us at eNCA. Take us through what happened in court. It was a very short judgment, ruling in favor of Maughan and Downer.
Basically, the court was giving out a short judgment and then said the reasons will follow later, where the physical judgment or the reasons behind the judgment are going to be disseminated. It's a 58-page judgment basically detailing how they arrived at the conclusion that they arrived at, which is that the application for, as brought by Advocate Billy Downer and Ms. Karyn Maughan, has been successful, meaning that the summons that were issued or that were taken by the former president to privately prosecute the two individuals have been set aside, and the former president is then interdicted or restrained from taking any further action pursuant to those particular summons. It basically means that they can't go back to the magistrate court or any other dispute resolution forum on that matter and then say, I'm bringing you here in this forum so that I can be able to privately prosecute you. But the last one was the awarding of the cost on an attorney and on-client scale, which according to us is the highest scale that you can be able to find in terms of the court order, and one which is usually given in instances where the court is sending out a message of saying that, this particular matter could have been resolved much easier. There was no need for this application to take place. So to sort of punish the receiving party, in this case the former president, let's award the cost on the highest scale which is possible. Now, glancing through the 58-page judgment, one could be able to see that there was also mention of agency, saying that yes, the matter was indeed urgent according to our own determination, but most importantly, the nulla prosecutor certificate, which is not suspect or name specific, which is not tailor-made for a certain individual, in this case Ms. Karyn Maughan, is one of the things which were considered by the court. Now, that gives an indication of what may happen in the type of interpretation which may follow in the Gauteng High Court, where the matter between the former president and the current president is currently taking place, currently surrounding the definition or determination what is a valid nulla prosecutor certificate, and it's one of the matters which were considered by the court. Also, the right of media freedom was also considered by this court, and coming to the conclusion of saying that there was no need for this type of summons or for this type of prosecution to take place. On that basis, that is why they are saying to Ms. Karyn Maughan and Advocate Billy Downer, we are going to grant you the relief in which you seek. We are setting the summons aside.
Yeah. In your view, do you think that the former president will appeal this ruling?
I think so. If you look at the manner in which the judgment is written, even though it does contain a few clarity or clarified positions of law, I think the interpretation in which they've argued earlier is way different from what is written in the judgment. So they may come back to this court and apply for leave to appeal and say to the three judges, we so believe that the SCA will come to a different conclusion. Either on a point of law, your interpretation was incorrect, or either in accepting certain facts, it was not incorrect. Can you please allow us to give us the opportunity to go to the SCA? Maybe the SCA is going to find in our favor. Even the court, if so, is due to two reasons or a number of reasons. The first one is that we haven't had yet many number of private prosecution cases that have taken place in our courts. So in terms of our jurisprudence, we do need a bit of cases to go in there just to sort of clarify the legal position. What is the proper private prosecution? In what instances can it be issued? What type of instruments do you need? For example, your summons, the nulla prosecutor certificate which is required, how must it be crafted so that it's much more clear as to if a person wants to engage in those type of prosecutions, how ought or what is the position in the procedure that ought to follow. And then secondly, the use of civil proceedings to stifle or to stop criminal proceedings from taking place is the route which has been followed by Advocate Billy Downer and Ms. Karyn Maughan the most appropriate one? Are there other ways in which the interpretation could be conducted, or these matters could have been resolved? Or is it the court looking from an instance of saying that I'm here to protect the interest and the rights of certain individuals? If they so see that the civil court will come to a much more quicker conclusion, let me do that rather than going to the criminal court, allowing section 106 in terms of not to prosecute defense to take place. Let me short circuit these proceedings, because I do feel that my rights are being infringed. So it's one of those matters which will need to be decided by the court, and I'd say the matter is ripe for an appeal, either on the SCA or even the ConCourt, so that we have much more clearer defined legal principles when it comes to private prosecution.
Yeah. You know, Mr. Zigalala, it's been a back and forth between Downer and the former president. We've seen this case drag on. From the last time when we were here, the representatives from the former president argued for at least hours on why this matter should favor the former president. Take us through some of the things that we've heard before in courts, just the history, the back and forth between Downer and the former president.
The former president was basically saying you have a prosecutor who's meant to subscribe by the NPA Act and NPA Code of Conduct, and one of those is that you are not allowed to disseminate information which comes to your desk simply by the fact that you are employed as the NPA or the prosecutor. In instances where the certain information that needs to be shared by third parties or members of the media, you have an appropriate person who's able to do that. Now, the NPA then says it is an offense when certain information has been disseminated without the proper authority having been given. So that's where the position, or that was the position of the former president in terms of saying, Advocate Billy Downer, I so believe that you are the only one that could have had access to my medical certificate. You have someone who's saying that they received the certificate from you. On that basis, you have contravened this particular section. I want to privately prosecute you because I've laid a charge against you. The NPA has come back and said they're not going to prosecute one of their own. I'm left with no option other than to go the route of private prosecution. So that's how this type of measure actually started. How then Ms. Karyn Maughan got into the picture? Then it was stated that you are now an accomplice. So instead of the former president going back and saying that I need another prosecution certificate against Ms. Karyn Maughan, a blanket one was issued in which then the NPA then says anyone who is interested or who is implicated or is part of this particular matter can be prosecuted, which is a blanket prosecution certificate, and some would frown upon on that type of certificate, because you can't give blanket powers to a private individuals as the NPA. It has to be case specific so that you have looked into the matter in appropriate eyes. So that's where the court was coming to in terms of discussing. Is the route selected by the former president in terms of obtaining the null prosecution certificate, instituting and making sure that you're able to bring the person to court, the most appropriate one? But also let's look at the merits. Did they do something wrong, or was everything done according to what the law ought to have been? And that's what the court was able to decide today.
Thank you so much, Mr. Zigalala.
Thank you very much for hosting.
Well, Dumelo, there you have it. It's Mpumelelo Zigalala from Zigalala Attorneys, just basically taking us through the history of this case and, of course, the judgment that was handed down today. The judge ruling in favor of Downer and Maughan on this one.
No, absolutely. And I heard you, of course, begin to Mpumelelo Zigalala about whether or not there is a possibility to appeal here. Not surprising to hear him say they would, of course, be expected to apply for leave to appeal. This, of course, as some conversations around possible delay tactics from former President Jacob Zuma continue to spike on. But thank you so much, colleague, for this update. The breaking news that, of course, the judgment with regards to those prosecutions against Karyn Maughan and Billy Downer have been, of course, rejected with costs. This being in favor of the pair and against former President Jacob Zuma.